Good morning. We are going to go ahead and get started with Chapter 8, the lawsuit preparation for trial. And I will be going through some of the slides pretty quickly just so that this presentation is under 10 minutes. Please note that any slide that I do not go over in detail, I feel that you can go back and you can read in its entirety if you have any questions. You will be responsible for this information on the test. So please make sure that you do go back and look at the information more thoroughly or ask questions of me through our Canvas conferences or my virtual office hours if you need any clarification on anything. So before we begin, go ahead and open up your notes that are linked to your agenda for today and follow along. First couple slides are where the objectives are. Basically, they are just telling you that this is going to be some investigation that we are going to do before the trial begins and all the way up to the jury selection. So we're going to start here with litigation. This is a term that you were probably exposed to back in the fall with your legal terminology, but this is where we're going to argue our case before the court, basically at what it means. This can be done both in criminal or civil action. This is initiated when we file our complaint or any of our papers, all the pleadings and the court forms with the clerk of court. These documents must be typed up. And so that's why with this unit, chapter 7 through 9, we have a lot of typing of legal documents because all of these documents would be required to be in typewritten form if we would be filing them to the clerk of court on behalf of our client. The first document that they talk about here in chapter 8, you have been exposed to previously in chapter 7, and it's the complaint. We learned all of the formatting and the details of the complaint. One thing that hopefully you have recognized as you typed up some of these complaints, and specifically the longer ones, is that each allegation is set forth in a separate paragraph. Then at the end, if you recall, the wherefore paragraph is where the plaintiff is letting the court know exactly what they want in the form of a prayer. These documents are signed by the attorneys. Once the complaint has been filed with the clerk of court, the lawsuit is initiated. At this point, motions can be filed with the court. There are many, many types of motions, and we are just going to look at them in a general form, that these are just requests of the court to do something with respect to the case. There's a motion to quash, a motion to strike, which you guys will be completing that document later this week, a special motion to strike, a motion to compel arbitration, a motion for summary judgment, a motion for dismissal, a motion to exclude, to include, all types of motions that can be very detailed, and they can be either in written form or an oral presentation to the court. Once these have been presented, the judge will rule in favor or against the party that has submitted the motion. And if they rule in favor of, this becomes an order. It's an official order by the judge. It's prepared by the petitioning attorney. So the petitioning attorney is the attorney that's filing the motion or requesting that the order be granted. It can be either the plaintiff or the defendant. The judge will then, like I said, decide to sign or not to sign, if they agree or not agree. And this now becomes an order. This is going to either be introduced or excluded from the trial. An example of this to you guys is currently right now in our situation, the governor has issued orders, and these are things that we have to abide by in the coronavirus situation. We are ordered to stay in our homes. Certain businesses are ordered to close, and they have to abide by these or they are in violation of the law. Next, we're going to look at stipulations. We have stipulated in the past in our mock trial cases where we've stipulated with opposing counsel in pre-trial the gender, how we're going to refer to the witnesses that were not being called. But in real court, these are basically just agreements between opposing attorneys that are legally binding, and they could be for an extension of time to either take or not take a deposition, to amend a complaint, are just a few of the examples. And these, again, could be in writing or they could be presented orally to the court. It's just an agreement. Now we're going to move from types of legal documents that would be filed with the court to how we're going to bill our client. So we've already had an interview with our client and we've determined that we've had a cause of action. Based on this, we've collected information, we've started our new case file. We then started the complaint with the understanding that we have to do a lot more investigation. But now, before we continue, we want to make sure that we have an agreement with our client on how we are going to bill them. We have 5 different options. Option 1, we have the contingency fee contract. This is a percentage that we are going to get from the client's money that's awarded from the court if we win. Typically, this is around 30 to 40%. We created this. This was one of the last things that we did before you guys left, one of the last things that we did in class. The retainer is the second type or second way that we can bill our client. This is on a monthly billing cycle or yearly sometimes. This is when we want to have an attorney available pretty much 24/7 to answer our questions. It usually applies to businesses or schools. Somebody that is going to be in a situation where they're going to need legal advice any point in time. We use this in school all the time. Our retainer and simple things like expelling a student. What is that student's constitutional rights? Are we violating those rights? The attorney will then advise us on those. Third, we have fixed or flat fees. We're going to establish a dollar amount up front at the beginning of the case. And these are on uncomplicated cases and such as dissolutions, which is a non-contested divorce. Bankruptcies or adoptions are a few of the examples. Fourth, we have hourly fees. We want to charge our client hourly fees if it's a more complicated case. And we don't know exactly what we're getting into and the amount of research that's going to take. So we want to be billed on the amount of time or the number of hours that we spend on a particular case. And finally, statutory fees. These are determined by state statutes. Legislation tells us that we cannot take advantage of people and that we can only charge a certain amount for a particular service, generally used in probate situations. So this is wills, trusts, estate planning. And the legislation is saying you can't charge more for somebody to create their will or for the reading of a will than what we're going to allow you, because we don't want you taking advantage of people in an emotional circumstance. That concludes today's notes. So please make sure you go back and review, fill in any blanks that you have missed. And if you have any questions, please have those ready for me tomorrow during the office hours or Wednesday with our Canvas conference. Look forward to seeing you. Bye-bye.